Now, there's something that most people miss when they talk about this. LSAC has to operate under the Americans with Disabilities Act in the US and comparable disability law in Canada. They cannot simply deny legitimate accommodations in the name of security. If they overcorrect, they expose themselves to legal challenge. And so when we talk about tightening security or tightening scrutiny, that tightening still has to remain legally defensible. They cannot arbitrarily reject legit medical documentation. They can't discriminate against legitimate medical conditions. That means any increase in oversight has to be procedural, consistent, and compliant. In other words, LSAC has a very fine line to walk between security of the LSAT and complying with disability law. Now, there's this question someone asked, would something like agoraphobia qualify? Because agoraphobia is a recognized anxiety disorder, fear of being out in public spaces. And in severe cases, it could substantially impair someone's ability to function in public settings. And so, yes, in legitimate documented cases, it could technically qualify. But you can't just self declare your accommodations. You've got to get a formal diagnosis. You have to have licensed medical documentation, description of the functional limitations you're operating under, a specific accommodation request, and submit all of that through LSAC's internal review process. LSAC has decades of experience reviewing accommodations long before remote testing even existed. And so severe anxiety disorders could qualify, but stating a casual preference would not. Now, another layer here is jurisdiction.